instead of pushing the slides, I think I'm going to just ask each of you, if you could, to just look along in the handouts. Given Bob's introduction, I think I'll deviate a little bit from my planned presentation a bit. So let me just say a few things. I've been doing this for 25 years. Immigration is about all that I know. I spend a huge portion of each day working with dairy farmers and other agribusinesses, mainly in three primary immigration areas. Number one is helping companies ensure their workforce compliance obligations with the government. That includes doing risk assessment, internal I-9 audits, and then defending those companies who do get the type of Christmas gift that Bob described. Number two, and perhaps the reverse side of that, is helping employers legalize their workforce through the effective use of existing temporary and permanent visa programs. And then also, interestingly, helping employers also use some of the other types of programs that aren't exactly employer-driven but are more individual-driven to try to legalize workers that way. And the third main area that we work in is helping foreign investors who are investing both temporarily and permanently in different types of agribusinesses achieve permanent residence through their own investments. And that's a whole other area that also interacts with the first two. So I guess before I get into any more specifics on any of those three areas, come on, a question from somebody, please. No questions? Okay. Yes, sir.
How hard is it to legalize when, for excess expense, talking about that, is that nearly impossible if they're already here or not?
Okay, so let me use that question as a jumping off point for the point of discussion, I guess. So the first issue is, inevitably in any discussion that I have with employers, I like to ask, okay, do you all know what a Form I-9 is? Okay, so, and usually I get, hopefully you all do, but it all starts with the I-9 form. The I-9 form is the document through which every employer is required to verify the identity and the right to work in the United States of all employees. And by the way, all employees also includes owners in most cases who are employed by the business, and it also includes family members, even those that were born in the United States. And a very, very common mistake we see in almost every I-9 audit that we do for ag employers is that there are family members employed by the business, and there is no I-9 form for that person. Why? Because they assumed, well, I know that person's an American citizen, I was there at his or her birth, but it still is a finable event to not have an I-9 for those people, not to mention for others that perhaps were not born in the United States. So, once again, the I-9 requires the employee to present documentation, and the whole list of documents are included in the handout, proving both identity, and that typically is in the form of some type of government issued ID document that appears to reasonably relate to that individual, and then another document, or perhaps the same document in some cases, that also establishes that person's right to work in the United States. Under the law, employers are not required to be document fraud experts. And I repeat, you're not required to be an expert on what's real, what's not real, but you are required in good faith to look at the actual document presented by the individual. We can perhaps talk a little bit later if you want about whether it's a good idea to copy those documents or not copy those documents. And those documents must appear to be reasonably genuine and to relate to that person. And sometimes in the cases that we get into where there is an allegation that an employer knowingly hired somebody who was not authorized to work in the United States, at times it gets into the question of did the employer reasonably rely on those documents? Did the employer actually see the original document? If they did see the document, did the document appear to be genuine or not? I mean, these are some of the issues that we get into when we get into the whole area of audits. in the risk assessment that we do, and in the internal I-9 audits that we do, there's really two main things that we look at. Number one is, what is the potential legal liability of the employer if Homeland Security were to come in and audit you? And then we also look, apart from the legal ramifications, what would the operational impact be on the business if all of a sudden there were either a raid or an audit and you were to lose X number of your workforce? And as Bob just mentioned, these things never come up at a convenient time. They never come up at a convenient time. Now, the example, Bob, that you cited was a very extreme, unusual example because of some, quirks and some geographical issues and some personality issues that had come up. But there's never a convenient time for this to happen. Usually, in most cases today, this is started off by you getting all of a sudden a visit in person, sometimes by mail, sometimes in person, of something called a notice of inspection. And the notice of inspection tells you that you have 72 hours to turn over to Homeland Security all of your original I-9s for all personnel, typically going back 3 years, but it depends on the audit in question. They also ask you to provide other documentation, including your articles of incorporation, certain payroll documents, certain other business documents, and also they typically are going to ask if you have received any no-match letters from Social Security. They want copies of those also to see if you've received them and to see what your reaction, your response was to those types of no-match letters. You are generally required to turn over the I-9s within 3 days. Usually you can negotiate additional time to provide the other business documents. One of the common mistakes that we see employers make is they'll get this document delivered to them, and because it's rarely good news unless you were expecting an approval for a work visa or something like that from Homeland Security, usually when you get that kind of an envelope, it doesn't have good news in it. And often people don't want to open it because they don't want to see whatever the news is, and they push it aside and don't deal with it. Don't do that. I strongly recommend that if you get something like that, you contact either someone like ourselves or at least someone like Bakke Norman or your accountant for further guidance. But again, it all starts with the I-9, and then we go from there. Now, I-9 audits can be especially problematic and disruptive to agriculture for a number of reasons, starting with the fact that, let's face it, a very, very high percentage of workers in the industry are in fact undocumented. You know it, we all know it, and the government knows it. And if you look through the materials, you'll see that at present, the I-9 enforcement program has been a major enforcement tool used by the government to try to deal with the whole issue of immigration and immigration reform. You'll see that in the last 2 fiscal years, there were somewhere around 2,500 audits each year. The number for this year is way, way up. The types of fines that are being assessed against employers, even very small employers, can be very, very high. Often we'll see 5-figure fines assessed, and often in the mid to high 5 figures for what seem to be, really pretty minimal violations. Those of you that have larger businesses with larger number of personnel that might be impacted, the numbers can very easily get into the hundreds of thousands. There have been a few well-publicized criminal prosecutions against dairy owners and other ag businesses. So it is something that I encourage you all to take seriously. Now, sorry, I didn't answer your question. I'm going to try to answer it now, okay? So I'll step aside from my 9 audits for a second. So, one of the difficulties is, especially those of you that have family-owned businesses, is that, and I run a small business. We have somewhere between 12 and 15 employees. I like to think of everybody as family. I like to think that I know, by and large, what's going on in people's personal lives and family lives. The danger to you is, on one hand, by knowing too much, even if your I-9s are perfect, when there is an audit, we get into this whole topic of, did the employer have knowledge, either actual knowledge or constructive knowledge? Actual knowledge means that you actually did know. Constructive knowledge basically means that a reasonable person in your shoes should have known, based upon the totality of circumstances, that the people were undocumented. I should say that, as far as I can recall, the vast majority of I-9 audits and ultimate fines, the numbers can run quite high, but in the vast majority of cases, the fines that are assessed are not for knowing higher charges. They are just for having paperwork deficiencies. Either you didn't do an I-9 at all for the person, even if they were born in the United States, or the I-9 wasn't completed correctly by the individual or by the employer. And you can imagine that the fines for knowing higher charges can be quite a bit higher. The actual numbers and the matrix system that they use to assess fines, it's in the materials. And there are potential criminal penalties for pattern and practice of knowing higher violations. So the difficulty here, when I get that kind of question, is that when you ask the question, it already goes into the area of knowledge. And generally, I like to think the smaller the business, probably the greater the chance that you actually do know each person's individual circumstances. But first of all, the single most effective tools that employers do have to try to ensure a legal workforce is use of existing visa programs. So we, for example, work with lots of dairies and other businesses and very aggressively use the TN visa program. The TN visa is for professional personnel. It only covers Canadians and Mexicans. And the four most common occupations that it covers would be animal breeder, animal scientist, dairy scientist, agronomist, and even though those titles may sound really high and whatever they are, the U.S. consulates in Mexico basically give those types of visas for herd manager type positions, even I think assistant herd manager positions. The basic requirements are the person must have at least a 4-year college degree in a relevant field. The biggest issue is going to be that if anybody has any kind of adverse U.S. immigration record, so they were here illegally, they were caught at the border, they're not going to be able to get that kind of visa. But we encourage people, so if you do have people in your workforce that, let's say, are from Mexico originally, or you have any types of contacts through professional associations, many employers recruit very aggressively at the Mexican universities because it's really a great supply of, potentially qualified workforce. By the way, there is no prevailing wage requirement for the TN visa, which makes it also a very attractive visa. The person is generally given permission to be here in increments of 3 years, and that can be extended pretty much indefinitely. So again, that's going to work for your professional ag personnel. As Bob alluded to at the beginning, there's another visa program that many of you maybe have used in the past, which is called the H-2A visa. The H-2A is a shorter term temporary work visa specifically for agriculture, and it will really cover almost any agricultural position except for dairy milker type positions. Okay? It's really well suited to crops because it's most effectively used as a seasonal visa, but it can be used for other types of ag work, manual ag work, and it really, again, will cover almost anything except for dairy milking positions. But I would encourage you to be very careful because if you run a dairy and let's say you apply for the visa and you misrepresent the nature of the duties that are going to be performed, there are potentially serious consequences. So it's important to be truthful with the Labor Department and with the State Department and with Homeland Security about duties a person's going to be filling. Now, the question that was asked from the floor was, okay, somebody comes to you and says, okay, what can you do to help me legalize my workforce? And first of all, I would strongly encourage you to be very, very careful about sponsoring somebody for permanent residence, you as the employer, if you have any reason to believe they're here illegally. So what happens is you've got to file this thing called a labor certification, which requires you to advertise and show that there are no qualified U.S. workers for the job. The problems are threefold. Number one, in most of those cases, the waiting list for a green card is going to be so years that we all might not be on this earth by the time a visa comes through. Number two, if the person is currently here illegally, they may very well be barred from immigrating through your petition. And number three, and this is the biggest reason, that what normally happens if you file a labor certification with the Labor Department and it appears that the worker is not authorized to be here, you are probably going to get an audit very quickly from Homeland Security, if not a raid to come in and arrest that person. So those are some three pretty good reasons why you should be very careful about direct sponsorship. Just a quick anecdotal tale. This is a case that's going on right now in our office. As I mentioned, we also represent foreign investors who are investing in dairies and other businesses. And the requirement is that the person invest either $500,000 or $1 million, depending on where they're located geographically, in a business that's going to provide full-time employment to at least 10 U.S. workers. So one of the requirements, in addition to proof of the investment and proof of the business plan, is if the business is already up and running, you've got to turn over to Homeland Security copies of all the employment records and the I-9 forms for the employees. In the past, up until fairly recently, there wasn't such a focus on what was the immigration status of those individuals. So if you had a business, you were employing at least 10 people, you turn over the I-9s, and that pretty much guaranteed you of an approval. Well, now what's happening is the government is claiming, A, that unless you can show that the workers are American workers, an American worker would be either a U.S. citizen, U.S. permanent resident, or an asylee or refugee, they don't count as qualifying workers. And you very well may be bringing an audit on yourself. So in a recent case, we filed the investor petition, and then lo and behold, within a couple weeks of filing it, all of a sudden he gets a notice of inspection where they want to see all of his I-9s. To make it worse, the inspection notice was sent directly to the employer, who tried dealing with the inspection on his own, didn't tell us he'd been audited. Not a good formula for success. Okay, so just as a warning on that. Now, what are some things that you can do if they do come to you? Okay, and we try to be, we try to stay clear of conflicts of interest. Sometimes it's inevitable, but one of the things that's very effective right now is the Obama administration this last summer surprised us all that even though they've been very tough on the I-9 enforcement side, a program that we call the DREAM Act, or DACA, which is Deferred Action for Childhood Arrivals. Okay, so if you've got somebody that is under age 30, and you know they've been here for a long time. A lot of kids were brought from Mexico and other countries when they were young, and they've been working on dairies and other types of businesses. In many cases, that person now may apply for permission to remain here legally and to get work authorization. And we've seen this used by a lot of our dairy clients, have identified in their workforce these types of individuals, and it's a great program. It's very quick, it's very low cost, it's very easy. The basic requirement is the person must be under age 30, must have arrived, must be at least 15, have arrived here, must be, let's say, at least 5 years from at least the summer of 2007. There's not too much document, and either must be a high school graduate or must be currently enrolled in an educational program. And there's a lot of people out there who meet those requirements. So it's a very quick, cheap, effective way for people in that category to potentially be legalized. I'm amazed at the number of people working on dairy farms who have lived here for a long time, worked here for a long time, have met, fallen in love, and married American citizens, but have continued to be, living illegally because they're fearful for going through the immigration process. In many cases, somebody married to an American citizen can apply for permission for permanent residence. If they've entered illegally, they may have to apply for this thing called a waiver, which is like a pardon. But they're in most, not all, but in most cases, these are very gettable. It does take time. It does take work. There's a new program coming into effect shortly that is going to make it easier for people in those categories to get this waiver. The way it works right now is the person has to apply for the green card visa at the American consulate in their home country, and then wait abroad while they're processing this pardon without knowing A, how long it's going to take, and B, whether they're going to get it. Under this upcoming change, if the only problem is that they've been in the States illegally, they're going to be able to apply for this pardon before they have to leave. So instead of being gone from the country for many months or perhaps years, if everything goes as planned, they'll only be gone for a couple of weeks, which is better for themselves, for their families, and for their employers. So I'm not sure if that answered your question. And there are other programs through which you can also potentially legalize a worker, but those are the two main ones that we use right now, is people married to American citizens and people who qualify under this deferred action for early childhood arrival. So if you do have situations like that, even though I know none of you would know that a worker is illegal, they should contact an immigration lawyer, ourselves, or another law firm to try to see what those options are. There's a lot of really, really bad information that is out in the media and in the community, and it's really important to sort out fact from fiction as to what can be done, what can't be done. Other questions? Bob, how much more time do I have, if any?
I don't know. I haven't been keeping track.
Okay. Kate, are you keeping track? Okay. But I would, let me just, as a parting word, I would highly recommend to each of you that because of the high rate of audits, because of the impact an audit can have on your business, I would encourage each of you to at least, whether you do it on your own or through a lawyer, is to engage in some level of risk assessment. And that really starts out with, okay, what happens if immigration does visit me? And it goes back to making sure that you do have I-9s in place for each person. If you don't, do them now. Don't lie about the start date. Don't backdate forms. We usually recommend that if you're going to, if you detect defects in your I-9 policies or your forms, you do a little memo saying, as part of our efforts to comply with federal immigration law, we did a self-audit, or we did an audit with our attorneys or our accountants. We detected the following omissions or errors. We're correcting them. You make any changes that you're going to make in a different colored pen. Again, you don't backdate. That goes a long way when you do get audited to showing good faith compliance, hopefully getting you off without any kind of a fine, or if there is a fine assessed, helping reduce that fine substantially. Having in place a plan that if you do get a visit from Homeland Security, making sure that the owners or managers know right away so that you can act on it. Generally, a question was asked by one of the attorneys here, what happens if the government shows up at your place either with a search warrant or without a search warrant asking to come in? What do you do? My general philosophy is you're not going to get too far by fighting with the government. You're going to need them to try to negotiate a resolution to whatever the problem is. Usually they understand that you want to speak with your attorney, pick up the phone and call somebody, but do not do anything that's going to get you accused of obstructing justice or that's going to make your situation worse. Have in place a plan for if you have X number of cows that need to be milked over whatever shifts, have in place a plan of action that what's going to happen if, taking a good look at your workforce, okay, really and truly, what is the composition of my workforce? If the government were to come in, what percentage of my current workers would I lose, and how would we staff that situation? Because you've got cows to be milked or crops to be picked, whatever it's going to be, and you've got a business to run. So keeping in mind that we look at both the legal side of things, but also the practical side. Running a business is hard enough on a good day, and when the government comes in with an audit, it's not such a good day, and having those decisions kind of pre-made can help go a long way toward resolving these types of issues. So I'll be very happy to take questions afterward, or any other questions from the floor right now? Yes, sir. No, and the beauty of it is that there's nowhere on the paperwork that there are many types of immigration applications where you have to list their entire work history or their work history for the last 5 years. Nowhere on the form does it implicate the employer. The employer is not a factor in this. And there's a lot of concern in the community. There's naturally a lot of uncertainty and a lot of fear on the part of the applicants. But as far as we know, there is only going to be an adverse enforcement action if there's fraud on the application. So it's really a great opportunity. I know that Kate and I did an audit earlier this year with a fairly large Wisconsin dairy producer. And I know that in that universe of personnel employed there were quite a few people who were DREAM Act eligible. Now, at the time we did the visit, nobody had any inkling this was going to become a reality. But the minute that it did, we were able to mobilize the people very quickly, and within about 6 weeks they had work permits. So it's an effective tool for those that qualify. Any other questions? Okay, well, thank you very much for your time, and thanks for the invitation, Bob, and we're happy to answer any other questions that come up after the presentations.